Welcome to Human Rights Asia Weekly Roundup. I'm Natalie Young. This week's special program will focus on torture and fabrication of charges in the Philippines. On 23rd of June this year, Fernando Obidencio, an activist held in a jail in Mindanao, was released after 8 years of detention. The court in General Santos City dismissed the charges against him for possession of illegal drugs. In granting his appeal, the court held that the prosecutors had failed to prove Obidencio's guilt beyond reasonable doubt, judging it could not prove that the evidence they presented in court was the same as what they seized from him in September 2005.
No, I would really say that not in accordance with law, just like in my particular case. What happened was that the other party was not around. The judge should have dismissed the case because under the rules, it's important that all the parties should be around because that is a pre-trial. The pre-trial cannot be terminated without conference. That's why the parties should be present. But the judge just postponed it.
But Obidencio's arrest was well planned and targeted. The police and military monitored his activities and targeted to arrest him on allegations that he was a supporter of insurgent groups. In the Philippines, security forces routinely carry material evidence, like illegal drugs, firearms, and explosives, ready for planting when they make arrests. This is to make sure that even if they fail to get confessions by torturing arrested persons, they still have evidence to indict them. The manner in which the police arrested, tortured, detained, and prosecuted Obidencio with planted evidence was similar to the experience of three other men: G. John Macalinsel, Abubakar Amil Hassan, and Arsul Jita, who were held for bombing a mall in April 2002. In April 2010, the three accused were acquitted from 2 charges of illegal possession of explosives. After 8 years of trial, when the court held the evidence used by the police in court was planted.
Ang mga perpetrator is bias. Nga nung masulti na kung bias siya, dihang pagdakop pa lang or pag-raid or pag-arrest nila sa mga innocenteng civilian is kulang sila og data. Automatic, pagkakita nila sa tao kung mauna ang gitudlo, diretso na sila mo walay investigation. Dire-diretsong dalhon, matod pa, i-invite sa office. Pero, i-interrogate nila, pinaagi sa pressure nila sa mga tao para sana makasulti og tinuod kay pinapasakitan man sila.
In addition to planting evidence of suspects, security officers also arrest and torture persons to get rewards for arresting wanted suspects. Despite evidence that the persons they have arrested are not the real accused, police and the military do everything to justify their arrest. This was the case of Mojinar Dagam Caballo, an ailing man who was arrested in his hospital bed in Zamboanga City, Mindanao in March 2013. Caballo was arrested, tortured and detained for 9 months before being released on a court order. The court held that Caballo and the wanted suspect could not possibly be the same person. Again, Caballo's arrest was well planned and targeted so that the police and military could get the reward. His arrest demonstrates a pattern of a systematic and widespread practice of arresting persons to get rewards. A year earlier, Rolly Panessa, a security guard, was also arrested, tortured, and detained on allegations that he and Benjamin Mendoza, a wanted rebel leader, are the same person. The court, however, rejected the claim and ordered his release.
Yung sa tingin ko po siguro, yan nga po yung sa pera nga nakapatong po sa ulo ni Benjamin Mendoza, kaya kahit sino na lang po matawag ginamit po nila para lang po makuha siguro yung pera. Kasi po yung nangyari na po yun, lumagpas lang po sa dyaryo at saka may picture po nga nakita namin na gano'n na po ang nangyari, na huli daw, pinalakas po nila, nahuli na daw po yung Benjamin Mendoza at saka yung kasamaan pa po. Bali, hindi lang po kasi ako ang biktima dito, mayroon pa po.
However, for some victims, the ordeal lasts for many years. Some were either rearrested or forced to go into hiding to avoid arrest on fabricated charges. Among them is Franco Romoroso, an activist who was arrested, tortured, and detained in September 2008. He was later rearrested and tortured again, this time with 42 other activists, collectively known as Maroon 43, in February 2010. The charges on him and others were subsequently dismissed. Another victim is Aristides Sarmiento, an activist who was arrested, tortured, and detained together with 4 others in April 2006. He was released in August 2008, but he was rearrested again on another fabricated charge. He's still in jail today. The cases of Romoroso and Sarmiento are examples of collusion amongst the police, military, and prosecutors to detain persons challenging the government on the pretext of preventing counterinsurgency and terrorism. In reality, these victims are exposing corrupt practices by the government. This is also underlying the case of Tamujan Kokor Talawi, an activist from Sulu in Mindanao, which is presently detained in fabricated murder charges based on a forced confession. Tuluwi is prosecuted by a local politician whom is exposed and challenged because of systematic human rights violation in his community. Tuluwi is being prosecuted for attempting to kill a governor in May 2009. Despite the illegality of the evidence, the prosecution and trial goes on. While torture victims who have been exonerated and released are often rearrested based on other fabricated charges, security forces involved in torture and fabrication of charges are rarely held to account. One example is Jovito Palparan Jr., a retired military general. The local court issued arrest orders against him to answer the allegations of his and his men's involvement in the disappearance of 2 activists, Shirin Kadapan and Karen Ampano, in 2006. He remains in hiding. Another example is former Manila Mayor Alfredo Lim, who was seen on television cameras forcing a confession from a rape suspect. He was neither investigated nor prosecuted, but a policeman who was seen in another torture video was detained and prosecuted for torture.
Di ba ikaw ang hold up dito? Ha? Sino ba ang hold up sa'yo? Ito. O, ikaw daw eh. Ano? Magsalita ka. Hindi. Ibig sabihin, nagsisinungaling to.
Joselito Binayak, a police officer who was seen in a controversial video torturing a robbery suspect, is now being prosecuted for violation of the Anti-Torture Act of 2009. Despite some prosecutions going ahead against security officers who are caught red-handed torturing suspects or fabricating evidence, convictions and punishments are rare. For more on this, we have a studio discussion with AHRC's Danilo Reyes, Basil Fernando, and Bijo Francis.
We have identified some patterns on the use of torture and fabrication of charges to prosecute persons and then later release them because there's no evidence for them to be detained. Perhaps we could comment on what the responsibility of the government in this kind of cases, looking at the situations in the Philippines.
See, the question that would come to the mind of anybody who sees all these video clips about so much of overwhelming evidence of torture taking place in the police, the prisons, is this: why is the government of Philippines allowing this to go on? You have to come to one of the 2 conclusions. Either that the government want this to happen, therefore they are quite knowingly that all this is going on, they are encouraging it to happen, or that there is some failure of trying to take action against it. Whichever way, the problem is that the government is not doing its part, and therefore before anybody else, the responsibility of the government should be questioned by the people. Because if the government says to the police, stop torture, the police will stop. The blame must be on the government, and the responsibility must be taken by the government.
We had a brief discussion also earlier, Bijo. You mentioned that most of these cases that we have reported must have been already a public knowledge. So could you elaborate more on what you mean?
See, if adding on to what Basil was reflecting on, if one were to take a more radical approach or radical interpretation of what has been witnessed, now the facts of so many cases that we discussed today shows a pattern. Pattern is this, that for those people which the government, understandably under the instructions of the government, the police would want to trap as a red case, a red-handed case. They carry contraband materials with them. They plant evidence. They arrest the person for prolonged periods of time and then produce the evidence in court. And after 8 years, 7 years, 10 years of trial, the person is found not guilty and set off or sent off. Now, if I were to look at it from a very practical or very open criticism of the entire thing, to me, as a person who looks at the working of the justice system in the Philippines, I see it as all like a drama, which is prescripted, which is enacted, at the mercy of the people who have no other means other than to run the system through. So a person's life is put in restriction or put behind bars. Plus, in addition to that, you get tortured, you get brutalized, and so on and so forth. And at the end of the day, if the judge were to just send the person off, it means that the judiciary itself is playing or has played into the hands of what the government would want the institution to do. So it's like a drama, this is not justice process. This is not adjudication process. This is more like a drama which is enacted to portray an image that there are certain institutions in the country that functions. But actually it is not institutions that are functioning. It is not a functioning of the institution. It is the enactment of a prescripted drama that is done obviously for political purposes of the government, because in many cases you see that the persons who are detained are human rights defenders or political activists and so on and so forth. It also brings in the question as to what is the accountability of the state institutions. Now, what is the policy of the Philippines government to bring in the basic levels of accountability in the investigative agencies? What is the process, what is the policy of the Philippines government to make sure that judicial process, the trial process in your country, in the Philippines, is not 8 years long process where a person is denied bail? The whole purpose of a judge in any system, whether it is a civil system or civil law system or a common law system or whatever other civilized system of jurisprudence it is, the role of a judge, the adjudicator, is to see that the executive does not use arbitrary authority to limit the freedom of an individual citizen. In all the cases that we discussed, it is exactly the opposite that has been portrayed, where the executive, in convergence with the judiciary, works together to make sure that the person whom they want to target is targeted, is detained, is allowed to be tortured, and set free. What is the so this goes back to what Basil said. What is the responsibility of what is the kind of governance that we are talking about?
So what comes out is Philippines government want a bad system. That should be what the people should conclude, and that is what they should ask. Why is our government giving us a bad system?
That is all for this week's Human Rights Asia Weekly Roundup. For more information, log on to www.humanrights.asia. Thank you for tuning in and see you again next week.